Hi and welcome to this latest immigration law update video. In this video, I wanted to share with you a version of a webinar that I've created called Key Immigration Law Cases of the Last 6 Months. And this webinar is based on my LexisNexis immigration case law review covering July to December 2020. And for anybody who've not seen that, I've put a link to the PDF version below this video. Also below the video, I'll put a link to my slides, which I've uploaded as a PDF to Dropbox, and you can have a look at those and you'll be able to see the extracts from the key cases and use those in your representations, your appeal skeleton arguments, and your grounds of appeal. This is my pick and mix of the things that I think are the key cases of the last 6 months. There are cases that I haven't covered. So this is just a subjective look at some important case law from the second half of 2020. So let's get going. The first case is a case from the Supreme Court. It's on revocation of sponsor licenses and fairness, and it's the case of Pathan. And the Supreme Court in this case was looking at an appellant who made a tier 2 application. And whilst his tier 2 application was outstanding, the Home Office revoked his sponsor's license. And then some 3 months later, she refused his application on the basis that he no longer had a valid cause from a licensed sponsor. He applied for administrative review of that decision, and one of the grounds was that he should have been given the 60-day period in order to find a new sponsor. He judicially reviewed, and the case made itself way up all the way to the Supreme Court. Now, the Supreme Court were unanimous on one issue, but split on the other. So the Supreme Court were unanimous in finding that the Home Secretary breached her procedural duty to act fairly by failing to promptly notify the appellant of the revocation of his sponsor's license. But the majority of the justices, Lord Kerr, Lady Black and Lord Briggs, found that the Home Secretary was not under a further duty to provide a period of time following that notification to enable the appellant to react to the revocation of his sponsor's license. Lord Wilson and Lady Arden thought the law did impose this positive duty on the Secretary of State to provide some extra time. So a bit of a disappointing decision. Yes, there's a breach of the procedural duty, but the majority holding they didn't have to give a period of time. There is some help in paragraph 104, and from time to time I'm going to read some bits off my iPad where I've got the full judgments for you. 104 of Pathan, as Lord Briggs has said in paragraph 170, in appropriate cases, the rules of natural justice may require a party to be afforded time to amend his case in a way that cures an otherwise fatal defect of which he had, without fault on his part, previously been unaware. Whether this is required is, as Lord Briggs said, heavily context specific. But the question quite obviously arises for consideration where the circumstances are as they were in the present case. Now, in the present case, that failed, but you may be able to argue in your case that a period of time should be given. So that's the first case. We're going to move these quite rapidly. The next case is on deportation of Zambrano carers. So it's looking at the extent to which those who've been recognized as Zambrano carers can be deported. And again, it was the Supreme Court. And this case was following the decision of the court, or the decisions, sorry, of the Court of Justice in the CS case and the Rendon Marin case. And in those cases, the Court of Justice held that in exceptional circumstances, a member state may adopt an expulsion measure provided that it is founded on the personal conduct of that third country national, which must constitute a genuine, present and sufficiently serious threat adversely affecting one of the fundamental interests of the society of that member state, and it is based on consideration of the various interests involved, matters which are for the national courts to determine. So the question arose, was there a test of exceptional circumstances based on that quote I just read to you, which was from the CS case in the Court of Justice, before you could deport a Zambrano carer? In this case, Miss Robinson was the primary carer of a British son, and she had convictions for dealing in Class A cocaine, I believe. And the upper tribunal had held that she was absolutely protected from deportation as a Zambrano carer. The Supreme Court unanimously dismissed the appeal, and it had gone to the Court of Appeal, and the Court of Appeal had found that there was no additional requirement of exceptional circumstances. So she'd appealed to the Supreme Court, who unanimously dismissed her appeal and held that the phrase exceptional circumstances doesn't import an additional hurdle before a Zambrano carer can be deported from the territory of the EU. So it was remitted back for redetermination. So the use of that term exceptional circumstances is just an exception to the general rule. Lord Stephen says this at paragraph 57. On the contrary, as the Court of Appeal correctly decided, it was simply explaining that in the prescribed circumstances, an exception could be made to the general rule that Zambrano carer could not be compelled to leave the territory of the Union. It was not stating that certain undefined exceptional circumstances first had to be demonstrated. So that's two cases from the Supreme Court. Let's deal with some procedural matters now. And at the start of lockdown number 1, back in March, the president of the upper tribunal issued a guidance note on the 23rd of March 2020. And that created what is described in the JCWI case as an overall paper norm. So what was happening is the upper tribunal were determining the error of law stage on the papers. So they were sending out directions for written submissions, expanding on the grounds, and then dealing with the matter on the papers. Concerns were raised with the tribunal by organizations such as ILPA and practitioner groups, but the upper tribunal stood firm, and JCWI launched this judicial review, got permission, and the substantive judgment was by Mr. Justice Fordham on the 20th of November 2020, and he found the presidential guidance note unlawful. And I'll read to you from the slide, because it communicated that appeals should normally be decided on the papers rather than at remote hearings during COVID. That position is inconsistent with basic common law requirements, which inform the overriding objective of just and fair disposal, which judges are duty bound to comply. And look at number 3, he says the guidance note is also unlawful because it said the fact that the outcome of the appeal is of importance to a party or another person will not without more constitute a reason to convene a hearing to decide the relevant questions. That is advice which is A, erroneous in law, and B, which would, if followed, lead to, permit or encourage unlawful acts. Now, as part of the order, there was a recital in the order that this judgment should be brought to the attention of parties affected, appellants affected by this decision, who had their appeals dismissed on the papers by the upper tribunal during this time. And it may be that those people will now have to make an application to set aside that judgment and to rehear the appeal at an oral hearing. A lot of those clients you may have already dealt with by now, but there still may be some people around who've been affected and perhaps didn't realize, and you may need to make an application on that basis. We've now seen a resumption of error of law hearings by Skype for Business. So the upper tribunal, the first tier tribunal, are using the CVP platform for their appeals. The upper tribunal for now, because Microsoft are obviously getting rid of Skype for Business and replacing it all with Microsoft Teams, but the upper tribunal are using Skype for Business for error of law hearings, so be aware of that. Let's stay on the issue of remote hearings and look at the judgment of the Lord Chief Justice in the FB Afghanistan case. Now, that was the challenge to the Home Office removal window policy. And in that case, the Court of Appeal, which was the Lord Chief Justice and Lord Justice Hickenbottom, found that there was nothing inherently unlawful about removal windows, But in this case, they found the Secretary of State's policy unlawful on the access to justice point. I'll read to you paragraph 87. They found the policy incorporated an unacceptable risk of interference with the right of access to court by exposing a category of irregular migrants, including those who have claims on Article 2 and or Article 3 human rights and protection grounds, to the risk of removal without any proper opportunity to challenge a relevant decision in a court or tribunal. That's paragraph, 147. Paragraph 87 is where they found there was nothing inherently unlawful about removal window policy. So that's from 147. And they go on to reflect on the Kairiri and Binlos judgment of the Supreme Court and the phenomenon, that was the phenomenon of deport first, appeal later, and the appeals from abroad. But it raised a wider issue, and because there were issues in Kairiri and Binlos about the whole practical thing about being able to appeal from abroad and to be able to do that electronically. And if you go back to 2011, and I put the citation there in NARE, evidence by electronic means, Zimbabwe 2011, UK UT 443, the upper tribunal in that case made some very strict requirements on what they'd expect. I think somebody had to notify the embassy abroad or have to be in a lawyer's office, and all these things that had to be done before somebody could give evidence from abroad. But look what the Lord Chief says in the middle of this paragraph. In the intervening years, both have been transformed and their use has become ubiquitous in courts and tribunals the world over, a process accelerated by the effects of the COVID-19 pandemic, which has swept around the globe since the beginning of this year. Lord Wilson discussed the cost of hiring video conference rooms and equipment, for example, which have long ago become an irrelevance in holding online video meetings. From the point of view of a litigant, whether discussing a case with legal representatives, attending a hearing or giving evidence, all that is required is video-enabled device attached to the internet with widely available commercial software installed in it. The position in courts and tribunals is entirely different from how it was even 3 to 4 years ago. So we may see now the ability of people to give evidence from abroad. We may see now the Home Office sort of moving forward with the deport first, appeal later, and the certification on those grounds. But it's just of interest because I've had a couple of scenarios and cases recently where clients have given evidence from abroad and no objection has been raised on sort of NARE grounds. Now, on webinars that I've done, some solicitors have told me that they had judges prevent clients giving evidence from abroad, for example, relying on NARE. I understand from talking to somebody who's a part-time judge that the judges have had some guidance on this. I haven't seen any published guidance on what the tribunal's current position is. But recently I had a case adjourned, and after the adjournment, Asylum case, one of my witnesses went back to Kurdistan, northern Iraq, got stuck there because of the pandemic. When we came back, we had a live hearing in Manchester, and the witness gave evidence on one of my devices in court. I think it was my laptop, by Skype. So, and there was no objection from the Home Office or the judge in that circumstance, and the witness gave evidence. Then recently I had a 32011 frustrating the immigration rules, where the client was obviously outside the United Kingdom, but her British sponsor was also outside the United Kingdom. They'd gone holidaying effectively in other countries so they could stay together whilst the appeal was pending. At the time of the appeal, my appellant, who was an American national, both my appellant and her British sponsor were in Turkey. They were in different flats at the time of the hearing, but both gave evidence, the sponsor and the appellant, from Turkey on the CVP platform to the first tier tribunal. So they had the CVP link, just logged in and gave evidence. So that allowed for both a sponsor to give evidence when he was out of the country, but also an appellant who often you wouldn't get the opportunity in entry clearance cases to call. And then recently I did an adult dependent relative. It was a granddad coming in, and the two sponsors, two of his grandchildren, one was in the UK, one had popped back to Pakistan to visit granddad. The hearing had been listed quicker than we expected. He was still in Pakistan. And he was with Grandad and actually was able to give evidence on the CVP platform, no objection from anybody, and give up-to-date evidence of how Grandad was, because he was there with him now. So obviously we expect guidance, and I think the upper tribunal, as I've put in the note there, will need to revisit the decision in Nare, but it'll be interesting. Now, just because you can call your appellant from abroad doesn't mean you should. You need to tactically think about that and whether that is an advisable course of action. But if you do want to call somebody from abroad, I would refer to paragraph 198 of FB Afghanistan, and it was recently in the Balda case cited by Lord Justice Hickenbottom about that, the ability to give evidence using modern software such as Zoom, Microsoft Teams, Skype, etc. Now, in the last 6 months, it's changed tack. Sorry, we're going to be changing subjects in this pick and mix webinar. In the last 6 months, there has been quite a lot of case law involving the national referral mechanism, trafficking cases, and some really interesting trafficking decisions. The first of those I want to look at is the case of MN. Now, it's a monster judgment. Lord Justice Underhill should get some sort of award because of all the judgments he's written this year. I think 3 of the most significant judgments on this webinar have been written by Lord Justice Underhill, and all 3 of them are very comprehensive, significant judgments. But MN was a trafficking case. Now, don't sort of fast forward if you don't do much trafficking, because if you do asylum law, this case is important in terms of expert evidence and the general approach to credibility and experts, and also the general approach to credibility. So the main challenge was rejected by the Court of Appeal. There was a challenge that where somebody had a positive reasonable grounds, even if they had a negative conclusive grounds trafficking decision, they still should be entitled to the protections and benefits under the Trafficking Convention. That was rejected by the Court of Appeal. But then they went on to consider the question of experts and credibility. So let's look at expert evidence. Again, this is not in your slides. I'm just going to get the judgment up on my iPad, but make a note of these paragraphs because they'll be important for some of your submissions, ASAs, and particularly maybe grounds of challenge in credibility cases. So Lord Justice Underhill does a great summary of the approach to credibility and experts at paragraph 121. And there's 6 sub-paragraphs to 121. Let me quickly summarize them. 1 says this: the decision whether the account given by the applicant is in the essential respects truthful has to be taken by the tribunal or competent authority caseworker, for short the decision maker, on the totality of the evidence viewed holistically. That's an important point. 2, where a doctor's opinion properly understood goes no further than a finding of mere consistency with the applicant's account, it is necessarily neutral on the question of whether the account is truthful. 3, however, this is really important, it is open to a doctor to express an opinion to the effect that his or her findings are positively supportive of the truthfulness of the appellant's account, so going beyond mere consistency, and where they do so, that opinion should be in principle taken into account. 4, such an opinion may be based on physical findings, such as scarring, but it also may be based on an assessment of the applicant's reported symptoms, including symptoms of mental ill health and or of their overall presentation and history. Such evidence is equally admissible. I'm not going to read on, but have a look at that. That's subparagraph 4. 5, the weight to be given to any such expression of opinion will depend on the circumstances of the particular case, and it cannot be determinative. 6, one factor bearing on the weight to be given to an expression of opinion by a doctor to the applicant's reported symptoms support their case that they were persecuted or trafficked is whether there are other possible causes of those symptoms. And he goes on then to refer to some case law. So it's often, say in scarring reports, important that doctors rule out other possible causes using the Istanbul Protocol. At paragraph 122, Lord Justice Underhill goes on to say, well, look, we've been looking at particularly evidence from doctors, but there's no reason why these guidelines can't apply to other types of experts. Then he goes on to credibility, and they're critical of the Secretary of State's guidance because they talk about assessing credibility, mitigating circumstances. Now, the Court of Appeal say one, mitigating circumstances sounds like a criminal case, and you're dealing with potential victims of trafficking, not criminals. And secondly, mitigating circumstances implies you make a conclusion first and then looking at mitigating circumstances rather than this holistic approach to credibility. So have a look at that. Then finally, paragraph 127. Again, this will be important when you're drafting grounds of appealing credibility refusals. Paragraph 127 says this: we would add one further point about language. The term credibility is used a good deal in the context of both asylum appeals and of decisions whether a person is a victim of trafficking. And we have detected a tendency to treat it as having some special technical meaning. But in truth, it connotes no more than whether the applicant's account is to be believed. In making that assessment, the decision maker will have to take account all factors that may bear on that question. Likewise, the term plausibility is not a term of art. To say that a particular account or element in that account is implausible is simply to say that it seems to the decision maker to be inherently surprising, or the kind of thing that you would not normally expect to happen. And such an assessment will obviously feed into the overall assessment of credibility, though the weight to be given to it will depend on the degree of unlikelihood and how confident the decision maker can be about it. Perhaps both points are too obvious to need making, but if terms are used too regularly, they sometimes get in the way of the process of common sense decision making. So a helpful paragraph there as to the correct approach to credibility, which goes beyond trafficking cases and is relevant to a lot of asylum cases. Another trafficking case was the case of EOG. In that case, the applicant applied under the NRM at a time when she still had leave to remain. Now, her leave expired while she was waiting for the NRM decision, and the challenge was on the basis that there was a lacuna in the policy because it didn't, she had a positive reasonable grounds decision. She was awaiting for a conclusive grounds decision. There are huge delays in respect of that. And what the challenge was, and in that case, Mr. Justice Mostyn found that the policy was unlawful because it didn't provide the opportunity for such persons to be granted discretionary leave with perhaps a condition of a right to work. And he found that unlawful, and there was an unlawful lacuna in the policy. So the policy will need to be amended. Now, look, in this case, the person who applied had leave to remain when she applied under the policy. And that leave to remain had a right to work. So she was in a strong position. So when the reformulated policy we see from the Secretary of State, it'd be interesting to see whether it's a blanket approach or whether it just covers those perhaps who had leave when they applied under the NRM policy. But have a look at the judgment, really important, and also some stark figures as to the delay in trafficking decisions. One other case that I haven't put in your notes, but is another important trafficking decision, which you may have seen reported in the press, is LJ Kosovo. Well, at least I think it's called LJ Kosovo, because if you look at the decision on Bailey, it says LJ Kosovo at the top, but actually in the top of the judgment it says IJ Kosovo. But whichever it is, this is the challenge by a recognized victim of trafficking and a refugee, and she challenged the decision in relation to a permission to work. She wanted to work as a cleaner, but she was only given permission to work in a shortage occupation. And there was a challenge to the immigration rule, Rule 360A, and also the Home Office permission to work policy. The claim was successful in relation to the policy, not the challenge to the rule, and that the guidance was defective in the lack of reference to a discretion. So caseworkers weren't properly then considering the individual circumstances of an applicant. So hopefully this will lead now to more discretionary decisions where they'll consider granting work outside the shortage occupation. So that's another helpful trafficking decision, either LJ or IJ Kosovo, and that's 2020 EWHC 3487 admin, and it's a decision from the 18th of December 2020, and it's a decision of Mr. Justice Bourne. So have a look at that. We're going to change topics now, and we're going to go to, again, one of the major cases of the year, perhaps in the top two, I think, for certainly this 6 months, and that's the Hock case in terms of Rule 276B and gaps in lawful residence. And this, again, is a decision of Lord Justice Underhill. And in this case, it was considering the decisions of the upper tribunal in the Junaid Ahmed case and the Court of Appeal in the Masoom Ahmed case. Now, there's a big danger in this case that we get bogged down in the weeds. So what I've done, I've put paragraph 8 on your slide. So have a look at that. And this is where Lord Justice Underhill sets out Rule 276B, the 10-year-long residence rule, which I'm sure you're all familiar with. But he's added some annotation to it. So we'll have a look. So there are 5 requirements there, and the first one is that 1A, he has had at least 10 years continuous lawful residence in the United Kingdom. That's important, so remember that. 2, having regard to the public interest, no reasons why it would be undesirable for him to be given indefinite leave to remain on the ground of long residence. 3, not fall for refusal under the general grounds. 4, sufficient knowledge of English language and sufficient knowledge about life in the United Kingdom. So 2 to 4 we can pretty much put aside for our consideration now. And then 5. Now he's added the capital A, capital B, capital C. So his capital A, the applicant must not be in the UK in breach of immigration laws. B, except that where paragraph 39E of the rules applies, any current period of overstaying will be disregarded. And that they referred to as open-ended overstaying in the judgment. C, any previous period of overstaying between periods of leave, they called that book-ended overstaying, will also be disregarded where A, the previous application was made before 24th November 16 and within 28 days of the expiry of leave, or B, the further application was made on or after the 24th of November 2016 and paragraph 39E of the rules applied. And what Masoom Ahmed said is you can't use any of paragraph 5, Roman 5, to make up your 10 years lawful residence in 1A, that they're separate requirements and you've got to have your 10 years, and nothing in Roman 5 helps you to get to 10 years lawful residence. The problem with that is it rendered the bit C about previous periods of book-ended overstaying, it rendered that pointless, that would never apply and help anybody. And actually, the Secretary of State still in her policy always accepted that where your gaps were in those periods, they could be disregarded and your 10 years was okay. So what happened? Well, the Court of Appeal and Lord Justice Underhill found that, let's look at A, the applicant must not be in the UK in breach of immigration law. So that's about current status. So B, except that where paragraph 39E of the rules applies, any current period of overstaying will be disregarded. So B definitely relates to A. It's about current overstaying. So he says you can't make up your 10 years about that. You know, normally paragraphs relate to each other, and B relates to A, and it's about your current status. So there's a provision in 39E that you can make an application now as an overstayer, but that doesn't, you can't make up your 10 years out of that period. But C is about a previous period of overstaying. That doesn't relate to A. It's not about your previous status in the your current status in the United Kingdom. It's about previous book-ended periods of overstaying. If we're going to make any sense of that provision, it must relate to 1A, about your 10 years lawful residence. So he says, look, this is a terribly drafted provision. and we'll see now in a minute, all of the Court of Appeal were critical of this provision, and the immigration rules generally, and the fact that different things were argued before the Court of Appeal and the policy. But to make sense of it, C must relate to 1A and your 10 years lawful residence. So if you've got these bookended gaps before 24th November 16, between periods of leave less than 28 days, or after 24th November 16 and 39E applied, your 10 years is okay, your 10 years lawful residence is intact, but you can't rely on the 39E period to make up your 10 years. So in that sense, Junaid Ahmed was right in respect of B, but Masoom Ahmed was wrong in relation to C. So he says, if I'm right up to this point, it must follow that Masoom Ahmed, which was concerned with past overstaying, was wrongly decided. I've already acknowledged that it normally would be sufficient to proceed on the basis that a disregard under subparagraph 5 could not have an effect to qualify the requirement under the wholly distinct subparagraph 1A. But in my view, that argument must yield to the considerations developed above, which centre on the fact that if element C were to be treated as qualifying subparagraph 5, it would have no purpose or effect. I obviously differ from the court with that's in Masoom Ahmed with considerable reluctance, but I note that it was not referred to the drafting history, including explanatory memorandum, and as will appear, the Secretary of State's position before it was fundamentally different from its position before us. So they find that Junaid Ahmed is correctly decided, although it's too wide in applying to both disregards. Junaid Ahmed is correct as it applies to B, but Masoom Ahmed was wrong in terms of the bookended C overstaying. Now, just out of interest, we talked about 39E, and 39E has been amended by the Secretary of State in the light of COVID. So 39E is the exceptions for overstayers, and there's a new 39E3 that says this: the period of overstaying was between 24th January and 31st August 2020. Actually, they miss out the word of in the immigration rules, so it actually reads the period overstaying was between 24th January and 31st August 2020. No reference actually to COVID or anything like that. There's just this blanket exception now for overstayers, for where your overstaying was between the 24th January and 31st August 2020. So be aware of the amendment to 39E of the immigration rules. This is their postscript. This is the decision of Lord Justice Underhill, who is very critical of the drafting of the rules and recommends that that steps are taken towards implementing what the Law Commission have recommended in terms of the simplification of the rules. Now, we have seen massive changes to the immigration rules, particularly brought about by Brexit and the introduction of the new skilled worker routes and lots of new routes. What they're doing is adding them as appendices to the rules until the rules can be rewritten in their entirety. I should say that the Court of Appeal was split in terms of the outcome. In terms of Lord Justice McComb, he accepted the appellant's argument that all of the disregards could apply to the 10 years, but Lord Justice Dingemans agreed with Lord Justice Underhill that only C could qualify the 10 years lawful residence. So I'm not sure if it is the end of the story, but at the moment, that's the position with Hock. I want to give you an interesting case now from Northern Ireland. This is not in my Lexis case law review, but it's about dishonesty and documents. Now, it is a Northern Irish decision and it's not binding, but it's interesting who it's from. It's from the now Lord Justice McCluskey, formerly Mr. Justice McCluskey, and the former president of the Upper Tribunal. So somebody who knows what they're talking about in terms of immigration law. And this was a consideration of a case with a fraudulent birth certificate in an entry clearance case. It was acknowledged that it wasn't a genuine birth certificate, and the application was refused under 327A. Obviously, the issue was from the sponsor and the appellant. They didn't know it was a dodgy birth certificate, so they were saying there was no dishonesty. The Secretary of State's argument, based on the Adedoyin case. Now, just so you don't get confused, Adedoyin is the unanonymized name for the case we all know as AA Nigeria, the sort of leading case on dishonesty. And what the Secretary of State argued in the Northern Irish Court of Appeal in LLD, forgive me, is that Adedoyin, AA Nigeria, is confined to false representation cases and doesn't extend to false documents. And the Court of Appeal in Northern Ireland reject this. Now, the Secretary of State had based their argument on the English Court of Appeal decision in Hamid from 2019, EWCA Civ 1324. And effectively, in that argument, they were saying, effectively, if you submit a dishonest document, the document is dishonest, there's no need to prove then that the appellant or the sponsor was dishonest in that case, because the document is dishonest in itself. So what was said in that case is what Adedoyin also established, however, is that a false document is itself dishonest, and that fact avoids the need to establish dishonesty or deception on the part of an applicant or another. Now, Lord Justice McCluskey goes on to draw further attention to the judgment in AA Nigeria and said, look, you haven't considered the whole of the judgment, because actually at paragraph 65, Lord Justice Rick says this: it is plain that a false document is one that tells a lie about itself. Of course, it is possible for a person to make use of a false document, let's ignore the brackets, in total ignorance of its falsity and imperfect honesty, but the document itself is dishonest. And Lord Justice McCluskey says, we consider that properly construed and considered in its full context, this passage was not intended to suggest that a document is capable of being dishonest, whether in the Part 9 regime of the rules or otherwise. Human beings, classic McCluskey language, human beings are capable of being dishonest. Documents, in contrast, are inexhaustively either false or genuine, accurate or inaccurate, correct or incorrect, and so forth. The assessment of a document entails a purely forensic exercise. The assessment of whether a human being is engaged in dishonesty is to be contrasted. The latter assessment involves exploring the state of mind of the person concerned and the making of findings, which will normally be based on appropriate inferences and sometimes less typically in practice on direct evidence, such as written or oral statement, evincing an intention to deceive. So they say Adedoyin, AA Nigeria, is not to be construed too narrowly at the expense of the rest of the judgment, and they disagree with what the Court of Appeal say in Hamid. They also look at it through the lens of the case of Ivy from the Supreme Court, which is the leading case of dishonesty, and find that reinforces their conclusion that the Hamid case was erroneously decided by the English Court of Appeal. So certainly something to be aware of where you're running an argument that a person has used a false document in ignorance of its falsity and imperfect honesty. Now, as you'll be aware, the general grounds of refusal in Part 9 of the immigration rules have been rewritten, and we've got a whole new framework to the general grounds of refusal. So do have a look at Part 9. I have done a video on that. It's broken down into 5 sections. Section 1 sets out what it applies to. Section 2 are the grounds for refusal or cancellation of entry clearance, permission to enter, and permission to stay. And in it now we see there are plenty of new grounds, actually. Involvement in a sham marriage or sham civil partnership grounds. That's a discretionary refusal. So now the replacement for grounds such as 327A is in 9.71 and following, which is false representations. And look at this. 9.71, an application for entry clearance, permission to enter, or permission to stay may be refused where, in relation to the application or in order to obtain documents from the Secretary of State or a third party provided in support of the application, A, false representations are made, or false documents or false information submitted, whether or not relevant to the application, whether or not to the applicant's knowledge, or relevant facts are not disclosed. So that's a discretionary ground. An application for entry clearance, permission to enter or permission to stay may be refused. But look at this now. There's a separate 9.7.2. An application for entry clearance, permission to enter or permission to stay must be refused where the decision maker can prove that it is more likely than not that the applicant used deception in the application. So you've got this discretionary ground where false representations are used or relevant facts are not disclosed, but you've got a mandatory ground where the decision maker can prove on the balance of probabilities that deception has been used in the application. So really interesting. Have a look at the new general grounds of refusal, some tweaks, some new rules. Some old rules have been rewritten and they're different now. So do have a look at those before you make applications, because you don't want to be caught out under the general grounds. And actually that brings me to another general ground that we're very familiar with because of tax discrepancy cases, Balajagari cases. Now, they were all refused under 3225, the non-conducive grounds. That was a discretionary provision, but now that's been changed. So look at the new rules. 9.31 is non-conducive grounds. An application for entry clearance, permission to enter or permission to stay must be refused where the applicant's presence in the UK is not conducive to the public good because of their character, conduct, association, or other reasons. So it's now a must ground. So 3225 is gone, 9.31 is now a mandatory ground. Now, Ashfaq is probably not one of the big cases of the last 6 months, but obviously I wanted to highlight it because it's the latest tax discrepancy case, and tax discrepancy cases have been an issue over the last 6 months. So we know in Balajagari that the Court of Appeal identified a procedural defect in terms of the Secretary of State not giving people notice of them that they're minded to refuse on these grounds. Now, those cases were cases that didn't have a right of appeal but carried a right of administrative review, and they ended up as judicial reviews. But a number of the cases have had rights of appeal, often because they're launched on a 10 years lawful residence basis. And the courts have, in a number of cases, and most recently in Ashfaq, said if the decision of the Secretary of State carries a right of appeal, the availability of the appeal process corrects the defects of justice identified in Balajagari. So the whole point that the Secretary of State didn't go through the minded to refuse process is not really going to be relevant when you've got an appeal and a judge can weigh up your explanation and consider that as part of their assessment of the case. Then secondly, Mr. Ockleton, in this case in the head note, it said, in an earnings discrepancy case, there is no a priori reason to suppose that any of the declared figures is or was accurate. In particular, the fact that a person is now prepared to pay a sum of money to HMRC does not of itself prove past income at the level claimed. So the argument has been made in a number of cases. Well, look, they've amended their tax return to come in line with their tier 1 applications, and they paid the tax, which shows they were earning the amount claimed. And a hole is blown in that argument by the upper tribunal that says, look, there's no reason to suppose that any of the declared figures were accurate. And they emphasize that's why you need an accountant to give evidence. That was said in the first half of 2020 in the Abbasi case by the president, but it's reiterated here by Mr. Ockleton. And without accountant's evidence, it may be that the tribunal finds the Secretary of State as the established dishonesty. So Ashfaq, not a sort of groundbreaking case, but it was a useful vehicle to summarize where we are with tax discrepancy cases. Let's change subject now and go to protection claims. Again, in a trafficking context here again, because previous decisions of SB and AZ were trafficking cases. DH, particular social group mental health, looked at the directive and the particular social group provisions, and where it said in the directive, you've got to show an innate characteristic and a recognizable group in society. And as long ago in K and Fauna, the House of Lords and the late Lord Bingham had said, well, actually, no, following the Refugee Convention, that should be read as, or they should be alternatives. You should either show an innate characteristic or a recognizable group in society. But the tribunal have rejected what Lord Bingham said in the House of Lords in cases like SB and AZ, and said, no, 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 you've got to show both. And then in those cases rejected that people were, I think those trafficking cases rejected that they formed a particular social group. Upper Tribunal Judge Hanson in this decision comprehensively looks at the Refugee Convention, etc., and rules that actually we should be following fauna and their alternatives. This case concerned a person living with a mental disability, and he also finds that people living with a disability or mental ill health will qualify as a member of a particular social group. It's a fact, or may qualify, sorry, as a member of a particular social group. It's a fact-specific assessment. In this case, it's interesting, actually, that the mental disability of the client was so complex, you couldn't put a label on it. And Upper Tribunal Judge Hanson also says in that case, well, just because you can't put a label on it doesn't mean they're not part of a social group. So the tribunal does not follow the previous decisions of SB and AZ. Notice they also look at the Afghani context, because in Afghanistan there's stigma and discrimination against people with mental health disabilities. So if you've got an Afghan client with mental disabilities, worth having a look at that. But generally very helpful in terms of finally clarifying and confirming what was said by the House of Lords back in fauna, that it's an or, not an and, in respect to the different limbs of a particular social group. A really welcome case was the case on asylum and gender identity, Mix M, gender identity, HJRR, terminology, El Salvador 2020, UK 313, decision by Upper Tribunal Judge Bruce. In this case, the appellant was a national of El Salvador, had previously identified as a homosexual male, had actually had a previous appeal that was dismissed on the basis it wouldn't amount to persecution on return. The appellant had changed their identity and was now non-binary in their identity, gender neutral, had grown their hair long and had dyed it very visible, which would attract more persecution, the argument went. Again, came before the first tier tribunal, again rejected, finding it wouldn't amount to persecution. The case went before Judge Bruce in the Upper Tribunal. She noted that neither the respondent nor the previous two first-tier tribunals actually used HJRR as a lens to assess the claim, and noted that the current judge in the fresh claim hadn't properly assessed the appellant's change of identity, which impact the social group that the appellant was now part of, and also found an error in the approach to persecution. There's a real helpful exposition of the sort of basics of what is persecution in this case. So she says, Upper Tribunal Judge Bruce says, decision makers should, where possible, apply the guidance in the Equal Treatment Bench Book and use gender terminology which respects the chosen identity of claimants before them. She does say that where you completely reject the account, so you reject that somebody's transgender, you don't have to follow that if you completely reject an account. But usually decision makers should use gender terminology which respects the chosen identity of claimants before them. And she says the principles in HJRR are concerned with the protection of innate characteristics. As such, they are to be applied in claims relating to gender identity. She finds an error of law in the decision, and then again looks through HJRR to assess risk and finds that the appellant is at risk, whether they would be viewed as a homosexual male in El Salvador or as non-binary. Whichever way they're viewed, they would be at risk given their current identity and the state of the country evidence. So a helpful case there in terms of gender identity. Finally, then deportation, the questions of unduly harsh, very compelling circumstances, rehabilitation and the best interests of children. Another decision of Lord Justice Underhill, HJRR, I think probably one of the most, if not the, perhaps it's recency bias by me, probably the most significant case of the year, I think. Probably I'll have to think back to some of the cases from earlier in 2020, but certainly the most significant case of the second half of 2020, overturning a number of sort of guidance decisions from the president of the Upper Tribunal. Just to track back from the case of KO Nigeria, in the context of deportation, we know that when assessing for medium offenders, so under 4 years, whether it's unduly harsh on the partner or the children. The focus is on the partner and the children alone, and is not a sort of weighing up against the public interest in their offences. What we saw happen after KO Nigeria is a number of decisions from the upper tribunal and the Court of Appeal overturning allowed appeals of the first tier tribunal, saying, no, 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 this is not unduly harsh, and you've got to show something out of the ordinary. This is just the ordinary effects of deportation. And this led to the appeal in HJ Iraq. And what Lord Justice Underhill in this case says, the upper tribunal self-direction uses a battery of synonyms and antonyms, although these should not be allowed to become a substitute for the statutory language. And it is an elevated test. And what he says is the underlying question for tribunals is whether the harshness which the deportation will cause for the partner and or child is of a sufficiently elevated degree to outweigh that public interest. But he says we must, even though it's an elevated test, unduly harsh, we must not lose sight of the fact that it's not as high as very compelling circumstances. So where it's above the low level that would apply in ordinary immigration removal cases, say in a 7-year child, a reasonableness test, it's above reasonableness, but it's below very compelling circumstances. And you cannot identify an objectively measurable standard to sort of compare the case against. It needs an informed evaluative assessment of whether the effect of deportation on this particular parent or partner or child, forgive me, would be unduly harsh. And he says there's a risk when what is said is that's what would ordinarily be expected by the deportation of a parent, or there's nothing out of the ordinary. Because if you're saying you've got to show something out of the ordinary, that is risking of applying a sort of exceptionality test. And unduly harsh shouldn't be elevated to exceptionality. And he says, actually, there is no reason to suppose why this couldn't happen in quite a number of cases. So have a look at the citations I've put in the slides, which are really helpful. 141 goes on to look at the impact of rehabilitation. Now, think what I've just said. In unduly harsh, you focus just on the child or the parent. So rehabilitation is not going to come into play in unduly harsh, but it will be relevant in the consideration of very compelling circumstances. So either where you're dealing with somebody over 4-year sentence, or you can't meet the unduly harsh test. Now, in the tribunal's decisions, they'd said, well, rehabilitation is not really relevant because all you're doing is getting back to being a normal member of society. But he says is that positive evidence of rehabilitation and a reduced risk of reoffending cannot be excluded from the overall proportionality exercise, and it must be an holistic assessment. But weight will vary from case to case, and it'll really be of great weight. Only exceptional cases you may be able to show that the rehabilitation is of great weight, but it is a relevant factor and it mustn't be excluded, and it could tip the balance, particularly in a case. So rehabilitation. Finally, best interests. There's a judgment from the second member of the court, Peter Jackson, Lord Justice Peter Jackson, who I think is a family law specialist, and he gives a short judgment on the best interests of children, which is worth its weight in gold and relevant generally in best interest case. So paragraph 154, a child will not usually be in a position to urge his or her point of view, and the decision maker cannot treat the child as if he or she had some burden of proof. So the assessment that has to be carried out is therefore one that is adequately informed and specific to the individual child as a person distinct from the offending parent. Now, Lord Justice Peter Jackson says there's 2 ways effectively tribunals or Home Office can go wrong. The first, paragraph 156, forgive me, is to focus on the position of children generally rather than the best interest of the individual child. And the second is by treating physical harm as intrinsically more significant than emotional harm. Obviously, that's why it's so important to have your evidence, like your social work report, your evidence from the school, your medical evidence, particular, to show the impact on that particular child, or if that particular child has particular health or psychological or learning difficulties, or things you want to put forward to show while it's unduly harsh. And again, he says that the words of the statute must be applied themselves, and there's no substitute for that. And he does make a comment which is quite helpful, actually, because there's often used aphorism that this is what deportation does, and it's a part quotation from Lord Justice Sedley in the case of A.D. Lee. But actually, what Lord Justice Sedley said in full is the tragic consequences is that this family, short-lived as it has been, will be broken up forever because of the appellant's bad behaviour. That is what deportation does. And it's usually that little sentence at the Home Office side. But actually, if you go on, Lord Justice Sedley goes on to say, sometimes the balance between its justification and consequences falls the other way. But whether it does so is a question for an immigration judge. So there needs to be a proper assessment, giving primary consideration to the best interests of the individual child concerned. And as if to hit the message home, Lord Justice Popperwell, who was the third judge on the panel in HA Iraq, has done two other cases where the upper tribunal had set aside allowed appeals in deportation cases of the first tier tribunal. And in both of those cases, he finds that the upper tribunal were wrong and there was no error of law in the decisions of the first tier tribunal. Effectively, what the upper tribunal were doing were just disagreeing, and because they would have made a different decision, finding an error of law. And he reminds everyone what Lord Justice Colson said in UT Sri Lanka about just because somebody might have a different position on would have made a decision differently doesn't mean it's an error of law. And he also reminds of the no need for extensive citations from authorities. So he goes on to summarize the position in Nigeria, summarizing the case law and about the unduly harsh test. Again, he says it in KB Jamaica. And there's a lovely potted summary of the law, actually, in terms of the unduly harsh test. So if you want a sort of nice crisp summary of the law, look at paragraph 54 of KB Jamaica, and I'll read to you subparagraph 4. The formulation in paragraph 23 of KO Nigeria does not posit some objectively measurable standard of harshness which is acceptable, and it is potentially misleading and dangerous to seek to identify some ordinary level of harshness as an acceptable level by reference to what may be commonly encountered circumstances. There is no reason in principle why cases of undue hardship may not occur quite commonly, and how a child will be affected by a parent's deportation will depend on an almost infinitely variable range of circumstances. It is not possible to identify a base level of ordinariness. And he gives the paragraphs from HA Iraq and the relevant paragraph from AA Nigeria. Beyond this guidance, further exposition of the phrase will rarely be helpful, and tribunals will not err in law if they carefully evaluate the effect of the parent's deportation on the particular child and then decide whether the effect is not merely harsh but unduly harsh, applying the above guidance. There is no substitute for the statutory wording. So a really helpful, crisp summary, and perhaps when you're doing your appeal skeleton arguments and the like, you might want to use that to summarize what the current state of the law is in terms of the unduly harsh test. And interestingly, in those cases, I think it's in the AA Nigeria case, actually, he found that the upper tribunal, when they said they took the first year's findings at its highest, weren't a proper representation of the first tier findings. So watch out for that. That's something you may be able to use to say, well, actually, no, that's an unfair summary of what the FTT actually found. And they have made comprehensive findings on why something is unduly harsh. The final case on deportation, and the final case in this webinar, is a case from the European Court of Human Rights called Unani. In this case, the appellant, a Nigerian national, had 3 British children, one of whom suffered from a rare congenital heart defect. Appellant sentenced to 5.5 years for offences relating to the falsification of some 30 applications for leave to remain in the United Kingdom. So not somebody who's going to be popular in front of the tribunal. His appeal was dismissed. He challenged the upper tribunal's decision on the basis that when considering very compelling circumstances, it had not conducted a proper proportionality assessment, considering all of the Strasbourg factors. And the European Court of Human Rights agreed, and they stressed the need, when you're considering very compelling circumstances over and above, it's a proper proportionality assessment, and that will include all of the relevant factors identified in Strasbourg and domestic case law, such as Bultif and Unna, and Maslov. So have a look at those cases, because they still have relevance when doing this proportionality balance. And actually, the court go on to make an assessment of Article 8, and they find, in the circumstances of the case, bearing in mind the seriousness of the offence, but it was not capable of outweighing the best interests of the children to justify expulsion. So a really interesting result, because you wouldn't expect to succeed in a case like that before often the domestic courts, the upper tribunal. So an interesting case to have a look at, because the European Court of Human Rights found that the decision to deport was disproportionate. So thank you so much for listening to this webinar. If you've made it to the end, you deserve whatever CPD points you can claim from this webinar. I hope it's really helpful to you. It's probably gone about an hour now, so you're probably able to claim an hour CPD. I know you're self-certifying now, but you should have your notes. You have my slides. If you've listened this far in, you'll be able to do that as part of your training. And hopefully this has provided you with an update on some recent case law, and you'll be able to use these cases as part of your submissions when making representations, skeleton arguments, grounds of appeal, and arguing cases before the tribunal and the higher courts. So thank you so much for listening. I hope this was helpful.